Next case that is set for argument is the Village of Grafton versus Kevin Killeen. Case number 18CA011326. Both parties are represented by counsel, so each will have 15 minutes to present oral arguments to the court. The appellant may reserve up to 5 minutes for rebuttal. Let me know if you're going to do that, and I'll keep you apprised of the time. We've read the briefs and are ready to proceed if you are.
Good afternoon, Your Honors. May it please the court, I would reserve 5 minutes for rebuttal.
All right, thank you.
Giovanna Bremke on behalf of Mr. Kevin Killeen. There are 3 assignments of error, sufficiency, manifest weight, and the third that the ordinance that is the subject of the matter ordinances are void for vagueness. This is a different case. It's an village ordinance. Mr. Killeen is an older gentleman. He and his wife, who is now originally charged in this case, but now deceased, Patty Jean Killeen, and her family has owned the property at 1116 Hickory Street in Grafton since the 1940s. There's 2 parcels. One parcel has a house and a drive, and then and you'll get to see photos in the record, which clears things up a little bit more. But the other lot has a gravel pad or driveway area. There's also a curb cut that the city put in that area. Prior to the passage of this ordinance, the paving ordinance. So there was 2 charges. One was for the paving, because there was at one point additional gravel put in that on that second lot that only contains the gravel pad. And then there's also a permitted use, meaning that there is an accessory use without a principal use. This same pad or drive was used, and there's different names because it's Mr. Killeen's wife. She took on his name. It's in her mother's side of the family. So there's different names, but all in the same family, all the same owners, same family that owned the property, passed down from the 40s. Dorothy McGill, it was the owner prior to the Killeens. That's Mrs. Killeen's mother, and her father, Clifford. They had owned it since 1940. When Mr. Killeen had inherited the property, then he rented it out. There was a tenant. In June of 2016, the village passed the paving ordinance, and there is testimony from the defense. They brought in several witnesses, and I'm going to go through those. That this driveway had been this drive or pad had been in existence since the 40s with continuous use since that time.
But wasn't that contrary to the photographs, the aerial photographs that showed no driveway?
No, there are photos, and I think what's significant is 2 people. I mean, there was a lot of people who testified, but the 2 people who are important, their testimony is the tenant, Doug Velva, and he testified that he essentially, he put in new gravel, but in order to do that, when gravel gets, sort of worn down, he scraped, some of the toppings off, and there was gravel there. So although
It wouldn't have shown up. Is that what you're saying?
yeah, so it was definitely used as this gravel pad. And the state also testified, or they also argue in the brief and at the trial, that there was a vacancy because Mrs. McGill had some health problems, had been out of the house. There was testimony about utility bills. There wasn't a lot of utility bills. But and the second person who's important is Patrick Killeen, who's Mr. Kevin Killeen's son. It would be Dorothy was his grandmother. And there was testimony from him that, yeah, we used to, there was a pop-up trailer that was there was a motor home, and we were going in and out with this motor home, going to Cascade Park to get ice cream in the motor home. There was, he said that when Dorothy went into the nursing home, that he would come and visit and check on the house, I believe he says at least weekly, and he parked in that gravel area. That they had a truck that was there because they were unloading her possessions from the home. So even during that time, again, in my mind, the utility bills, even if somebody's not living there, we're not worried about the inside, we're worried about this gravel pad and whether that's being used. So whether anybody's in that house or not, there can still be use of this gravel pad, and there was. And Patrick testifies that he used it even during that time where the house may have been vacant. And that's about transcript page 180 around is his testimony. There's testimony again from the current tenant that he placed additional gravel, but that there was gravel there already when he did that. There's testimony from Dorothy's nephew that there was campers and boats there. There's testimony from a niece that there's trucks and campers, that there was a water pump that was there, and there's a lot of talk about this water pump, and that where the gravel pad had gone up to was access to this water pump in a building that may have been there prior that got burned down. There was also a neighbor that had testified that she had lived there since 1986 and that the driveway was used continuously since then. Significantly, the village put in a curb cut when they came through and did the streets. They put in a curb cut in that area. And the way the village officials explain this is, well, if there's a future development, if there's a future house being built there, then that's why we put it in, so we don't have to go back through and do it. But what's significant is they put this curb cut in right where that drive is. So, but for there being an already existence of a drive, how would they know where to put that curb cut right there, right where this drive was? So there's a curb cut that clearly shows that there was this, there was use of this drive into this property. Actually, without that curb cut, and you can see in the photos, I don't know that it would even be usable as a gravel lot because, you would have to go up and over. So the curb cut is very significant, and that's something that, again, the village itself did, which shows that, there was an existence of a driveway or a gravel pad. It's, again, you can see the photos. Again, the two ordinances, there is another ordinance that basically says if anything is in existence at the time, they're grandfathered in, and that's what the law says as well. So when we're talking as far as sufficiency, and I kind of combine them, I know you guys don't like that, but the sufficiency factor goes to, and it's a little bit different because these are ordinances and zoning, but that are criminal at the same time. They're misdemeanors of the 4th degree. The grandfathering in provision that the state village, it wasn't able to meet their burden under these ordinances because they also have another ordinance in the law that says that grandfathering in over the time, since 1940 there was this gravel pad, and because that was in existence prior to the passage of these ordinances, that they're okay to be there.
Are you referring to a gravel pad in the same way as a gravel driveway, or are they two separate?
Yes, it is a driveway pad. If you look at the photos, I think everyone refers to it as a driveway. I kind of refer to it as a pad because they're parking campers, trailers, but again, it is, because of that curb cut, people are driving in and out, so it is a driveway. Again, there's testimony from all of these people, especially the grandson or son of Mr. Killeen, that there was always trucks, campers, boats there. That it was
never a house.
What was that?
But never a house.
That is, there's some debate in the testimony. There was and I think it's whether there was a Wisetail or not, I don't know. At one point, there was maybe a structure there that burnt down. There's conflicting, I think the village says that they don't really have record of it, but the Killeen say, yes, we heard about this big fire, and, you know, certainly that water pump is somewhat of a structure, and that's, what the testimony sort of shows is that that's why that originally was there, for this either structure that burnt down or the water pump, something along those lines, that had always been there since, you know, they had purchased it, and at one point it burnt down or blew down, something along those lines. The paving ordinance was just passed in June of 2016, and Mr. Killeen was charged less than a year later with these charges. The paving ordinance, again, was in existence at the time that this gravel, there was never a break in this gravel, you know, driveway or pad. There was never a break in the use, and there's testimony to that.
You're at 5 minutes, right?
Okay, I'm gonna address really quickly the ordinance as being vague. So again, this pertains mainly to the paving ordinance, and what it says is that it has to be dust-free and impervious, and the material. And they give, they say, okay, such as, and they give two examples. I believe it was concrete and asphalt, but it doesn't eliminate gravel as being dust-free and impervious. And what's significant about this is the standard for this is what the common intelligence would view as the meaning. And there's no better test for the common intelligence rather than a jury. And what the jury does have a question while they're in the middle of deliberations, and they say, hey, we need clarification on this paving. And what follows is a discussion between the judge and the council. And everyone has a different idea of what this clarification is, what the paving ordinance is. And so I think that that's significant, because it shows, you know, not only are these, you know, people with who I would say superior intelligence, the judge and the two councils, but also this jury of common people with common intelligence. None of them know what this paving ordinance means. Is gravel included in that? You know, gravel can certainly be dust-free, and you know, they don't say in the ordinance whether gravel is explicitly excluded, and common people have questions about it. So I will reserve the rest of my time.
3 minutes and 13 seconds.
Thank you.
Good morning, Council. You've got 15 minutes.
Good morning, Your Honors. Thank you very much. May it please the court, my name is Gretchen Holderman, and I am here on behalf of the Village of Grafton, the Appalachian. I submit to you, to the court, that the three assignments of error that appellant has raised should not be reversed, that in fact the evidence at trial was clear and consistent through multiple witnesses, that the property in question, the adjacent lot, was always vacant, that there was no structure on that property. If there was a camper or a trailer or a tent or something like that, that would not be a structure, and therefore there could be no ancillary use because there was no appropriate primary use of the property. Therefore, this was not an appropriate place for any kind of a driveway to be placed.
So there was no governmental record about a house previously being there
No.
that burnt down, or?
No, we didn't have any record like that. There was some testimony, but it was kind of disparate, even among the people that had some recollection of something having existed. But I think that the better part of any evidence would have been that there might have been like a camper parked once in a while. I would submit to Your Honors that there is no non-conforming use, but if there had been, that it is undisputed that any such use would have been abandoned. The appellant himself admitted that the lot had been vacant until the time when Mr. Valva expressed interest in renting the property. And furthermore, there was testimonial evidence by the building inspector that the lot had been vacant. The property itself had been vacant, and that was backed up by the city's records of the utility department that indicated that the utilities had been turned off because Mrs. McGill was in a nursing home. I would submit to you the evidence was clear, as testified by the police chief, Dan Clark, that in fact, on a regular routine patrol in late January of 17, he observed commercial vehicles parked in that abandoned or that side lot to the 1116 Hickory Street property, and he told Mr. Valva, listen, you can't do that, you can't park in that yard, and you're pulling all kinds of mud into the street, so you better clean it up. Chief Clark testified that not long thereafter, and he believed it was the very next Monday, not only had Mr. Valva not complied with his admonition, but that Mr. Valva had gravel dumped in that side yard and still had these vehicles parked there. The evidence is, I think, all over the record that Mr. Valva, the tenant, and Mr. Killeen, the owner, doubled down rather than doing what they should have done and availing themselves of requesting for a variance from the Board of Zoning Appeals. That is a mechanism in place that residents should do, and I would submit that public policy supports bodies like the Board of Zoning Appeals so that our residential neighborhoods like this have consistent, uniform uses of all of the private residential lots. I would submit to your honors that in this case, the evidence was quite clear from the village administrator that nobody had ever approached him as the official pursuant to the paving ordinance for any kind of permission. And if I can just touch upon the vagueness argument of the appellant, that as the court is aware, these legislative ordinances are presumed constitutional, but in any event, that whether or not the gravel that was put down would comply with the non-pervious material would be a matter simply resolved if they had asked for permission, because the village administrator was the authorized official of the city that could give such permission if it was appropriate. I would submit that the further evidence of Mr. Klein is the only evidence depicting the actual state of the lot, which shows photographic aerial photographs from satellite showing that in 2002, 2003, I think 2005, and then I think early 2017, that there was in fact no drive on that vacant lot next to the 116 Hickory Street. I would also mention that Mr. Klein talked to neighbors, and they confirmed that there had been no lot. And the village clerk treasurer, who lives across the street and has for 30 years testified, Mrs. Barnhart, that there was in fact never a driveway on that property. I would submit that the driveway is unsightly. It's offensive that the tenant and Mr. Killeen would just take this wholesale approach, and even as we are here today, have continued to park in this vacant lot despite the fact that the trial court or actually that the jury had found Mr. Killeen guilty of these offenses. I would also note that the testimony presented affirmed that the only people that submitted that there could have been a non-conforming use also in fact admitted that the property had been vacant for a period of years prior to Mr. Valva. So if there had been a grandfathered in non-conforming use, that non-conforming use would have been cut short by the abandonment of its use pursuant to this statute. So I'm not sure if the panel has any questions, but I would submit that the jury's verdict, having considered all the witnesses, the testimony, the photographs, the documentary evidence, certainly had sufficient evidence to find the defendant guilty as they did, and that indeed this court, as the 13th juror, should not conclude that such a decision was unreasonable. And finally, I would note that there was no challenge to the alleged vagueness of this paving statute, or if it's both statutes, ever made, so that issue was not preserved. But I would submit that regardless of that fact, that both statutes clearly tell any reasonable resident of Grafton the law that they need to abide by when living on this residential street of Hickory.
And I have a question. I'm going to apologize if you've already alluded to it, but what is the village's position on the import of that curb cut?
I'm glad you asked, because I forgot to say. Apparently, curb cuts on extra lots are very common. It's a lot cheaper for the developer to do the curb cut when they do the whole entire street than to come back and have to make a curb cut. There's also uniformity in the placement of the curb cuts. The prosecutor mentioned that maybe, that wouldn't be where they would want the driveway, and that's possible. But I think that there's a general consistency, and they could always change it, which would probably be the same as building it from the beginning. But the village administrator, Mr. Price, testified that it is not uncommon for them to go ahead and do a curb cut, as it is equally common for people to sell an extra lot on a residential street if they happen to own the adjoining lot next door.
So, was there anything in the record about the village's prior approval of that curb cut?
The curb cut doesn't, as far as I know, Your Honor, I don't believe that needs any kind of approval.
Okay.
It's the paving and the ancillary use to a primary use that were the main issues. But the curb cut itself is not in violation of any kind of statute in Grafton. Okay. If there's no further questions, I thank you.
Thank you. You have 3 minutes and 13 seconds then for rebuttal.
Yes, thank you. And again, I implore you to look at the photos in this matter. There are photos from prior to this, the passage of this ordinance, shows gravel. I'll submit to you, it wasn't as much gravel as there is now. That happens with gravel driveways, you have to replenish them. And so of course, because they did that, it was for the reason that there wasn't a lot there, but it was still there, it was still being used. I think it's not unsightly, it actually looks like it goes right with the house, it's right next to the house. You wouldn't know where one lot ends and the other one starts. And again, you can see that in the photos, you can see the curb cut in the photos. And my response to that is, again, if there wasn't a driveway there, and again, I don't doubt that it's not uncommon to put curb cuts in on vacant lots, but the placement of that curb cut is significant because it shows that there was that drive there in existence, and that curb cut was placed in that area for a reason. It's not in the middle of the lot, it's right where this drive is. It's right on the edge of the parcel. And I think it's significant because it's right there where there has been use of this driveway lot area. And it looks like it goes with the house. Again, you wouldn't know where one lot ends and the other one begins. Thank you.
Thank you both for your arguments today. The court will take the matter under advisement, issue a decision in due course, and the clerk will mail you each copy on the date it is released. The Supreme Court of Ohio also posts the opinions. Thank you again for your arguments.
Thank you.